Welcome to Do It for the Case Law, Monday, August 24th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 62 federal appellate decisions across 10 circuits. Our coverage spans criminal justice with a heavy focus on drug trafficking and firearms cases, civil rights matters including voting rights and Section 1983 claims, and significant Supreme Court and constitutional law developments involving habeas corpus and prisoner litigation. We also have business and labor disputes covering contracts, securities, and consumer protection, as well as immigration appeals and administrative agency reviews. If you want to stay current with federal appellate news, please subscribe to the show. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 24 cases on my beat today. The disposition roll-up is 19 affirmances, 2 split outcomes with partial dismissals and affirmances, 1 dismissal, and 1 vacatur with a remand for resentencing. Starting with the 10th Circuit, the court granted the government's motion to enforce an appeal waiver in United States v. Foster, dismissing the appeal under the narrow miscarriage of justice exception because the alleged sentencing error did not rise to the level of bringing the judicial system into disrepute. Moving to the 11th Circuit, the court affirmed 5 cases including Omar Garcia-Galban and Sean Hartsfield, where the court clarified that downward departures from mandatory minimums are strictly limited to substantial assistance factors. The court also upheld Keith Bernard Miller's robbery convictions, ruling that a polite or written demand for cash carries an implicit threat of bodily harm sufficient for intimidation, and affirmed Antonio Oscar Tatum's supervised release conditions prohibiting contact with specific individuals. Over in the 4th Circuit, the court handled 10 cases. Keshwan Sinclair received a split outcome where his appeal was dismissed regarding sentence reasonableness due to a valid plea waiver, but the court reviewed his plea validity claim under plain error standards. The remaining 8 4th Circuit cases were affirmed, including Daryl McHoney and Dimitri Rommel-Farr on supervised release revocations, Jonathan Edward Anderson and Robert Stewart on drug possession sentences, Darren Maurice McLean Sr. and Jr. on felon in possession charges with sentencing enhancements, Juve Markey Laquan McAlpin for premeditated firearm possession, Markel Lakeith Mason under the Armed Career Criminal Act despite colloquy errors, Antoine Winbush where the plea waiver barred most challenges leaving only a right to petition notice, and Dante Eugene Townsend on machine gun possession. The 8th Circuit affirmed 3 cases. Phoenicia Torres' conviction for possessing a firearm was upheld as constitutional under the Second Amendment following Supreme Court precedent. Conrado Perez's drug and firearm sentence stood despite a Bruin challenge foreclosed by circuit law, and Philip Darren Shockey's supervised release revocations were sustained as reasonable. Finally, the 9th Circuit affirmed Fernando Aguilera's conviction for possessing ammunition but vacated his sentence to allow for proper application of acceptance of responsibility guidelines, and affirmed Matthew John Nason's assault on a federal officer conviction, finding no plain error in jury instructions regarding constructive amendments to the indictment. Back to you, David.
Thanks, James. Let's turn to Aisha for the civil rights coverage.
Thanks, David. I have 12 civil rights and administrative appeals for you today. The disposition roll-up is 7 affirmed, 2 denied, 1 reversed and remanded, 1 vacated and remanded, and 1 group of routine affirmances. We begin with the 1st Circuit, where the court denied 2 petitions from Pereira Alves challenging the Board of Immigration Appeals' dismissal of their asylum and Convention Against Torture claims under the substantial evidence standard. Moving to the 10th Circuit, the court affirmed the dismissal of Chase Anderson's Section 1983 complaint for failing to meet pleading standards due to prolixity and lack of fair notice. In the 11th Circuit, the court affirmed 2 dismissals, one against Christopher Jackson in a pro se due process case where he abandoned his arguments on appeal, and another against Tavern Downing regarding allegations that were threadbare recitals of law without specific facts. We then turn to the 6th Circuit, which reversed and remanded the district court's grant of younger abstention in Professor Woodcock's case because the internal investigation was not yet an ongoing state proceeding. Also in the 6th Circuit, the court affirmed summary judgment for defendants in a foster parenting dispute where the plaintiff failed to show her proposed accommodation was reasonable under the ADA. The 6th Circuit also vacated and remanded Brent Perry's time-barred Section 1983 claims because Michigan's class action tolling rule applied to his filing following earlier litigation. In the 7th Circuit, the court affirmed summary judgment for Exiliad in Richard Hibaugh's age and race discrimination case, finding he could not prove pretext under the burden-shifting framework. The 9th Circuit affirmed the dismissal of Gobes Section 1983 Monell claim against the Las Vegas Police Department for failing to allege a policy or custom causing constitutional injury. Finally, in the Federal Circuit, the court affirmed the removal of Teresa Duran from her position with the Bureau of Alcohol, Tobacco, Firearms, and Explosives based on substantial evidence regarding medical inability to perform. That covers the remaining routine affirmance from the 8th Circuit. Back to you, David.
Thanks, Aisha and Rain. Now for Supreme Court and Constitutional Law with Michael.
Thanks, David. 3 cases in this block. All 3 were affirmed or dismissed without oral argument. In the 10th Circuit, the court rejected Andre Twitty's petition for a writ of coram nobis, holding that his due process claim regarding the Assimilated Crimes Act was previously litigated and could have been raised during his direct appeal or in Section 2255 proceedings. Moving to the 4th Circuit, the court affirmed the dismissal of Kenneth Liggins's civil complaint against Carlisle Hill and Zion Baptist Church of Berryville, Virginia, Inc., finding no reversible error in the lower court's decision. Finally, the Federal Circuit dismissed petitions for review of the Merit Systems Protection Board pursuant to the parties' agreement, ordering each side to bear its own costs. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business, labor, and civil matters.
Thanks, David. 13 cases in this block. The disposition roll-up shows 4 affirmances, 1 affirmed in part remanded, 3 reversals, and 5 vacators. Starting in the First Circuit, the court affirmed a civil contempt holding against Juan Carlos Reynoso for failing to comply with a federal seizure warrant regarding cryptocurrency assets, ruling there was no abuse of discretion in denying an evidentiary hearing since the record showed no genuine dispute of material fact. Moving to the 10th Circuit, 2 cases involving Alin Dumitrascu were affirmed. The court upheld the dismissal without prejudice of his amended complaint alleging fraud on the court, finding it was an improper collateral attack on prior Hague Convention judgments that should have been raised via a post-judgment motion under Federal Rule of Civil Procedure 60D. The panel also affirmed the denial of his motions for relief and judicial recusal, concluding Chief Judge Brimmer's impartiality was not reasonably questioned and that the virtual hearing format did not constitute an error.
Within the circuit, the court affirmed in part remanded in Jivan Malhotra versus Ajit Kumar, instructing the lower court to re-enter judgment dismissing the claim against an unserved defendant without prejudice, while affirming the dismissal with prejudice against served defendants for failure to substitute a deceased party within the 90-day deadline.
The court also reversed and remanded Wells Fargo Financial System Florida versus 5307 Seagull 2008 LLC, holding that the district court exceeded its authority by sua sponte remanding a foreclosure case without waiting for a formal motion based on procedural defects in removal. Over in the Third Circuit, 2 cases were vacated and remanded regarding arbitration rights under the Federal Arbitration Act. In Jane Park and David Hughes versus Avis Rent-A-Car System, the court found no implied waiver of arbitration despite the defendants litigating for a year and a half, noting that factual development on customer knowledge was required before a waiver could be found. Similarly, in Roger Salvatore and Sandra Salvatore versus XTO Energy, the court held that XTO did not waive its right to compel arbitration against unnamed class members even after participating in discovery and opposing class certification, as its conduct did not demonstrate an intent to relinquish the known right. Turning to the Fourth Circuit, 3 cases were affirmed. Brad Johnson was denied relief in 2 separate matters, one involving a dismissal on res judicata grounds and another regarding loan services, with no reversible error found in either instance. Sherry Richardson versus Toyota Motor Credit Corporation was also affirmed as the court upheld the dismissal for failure to state a claim. However, in Liz Badenana's Pieta versus Todd Blanche, the court granted review in part and denied it in part, ruling that the petitioner is not an alien convicted of a controlled substance offense because her underlying marijuana possession conviction had been vacated by a North Carolina court, rejecting the Board of Immigration Appeals framework for treating vacated convictions as valid. Finally, in the Ninth Circuit, the court vacated and remanded Golden Eagle Insurance Corporation versus Kamek, holding that an indefinite 18-month stay of federal insurance litigation was an abuse of discretion because the duty to defend is determined solely by comparing complaint allegations with policy terms without needing extrinsic facts. The panel also granted review and remanded in Melashi versus Todd Blanche, finding the Board of Immigration Appeals' adverse credibility finding regarding omitted employment history lacked substantial evidence as it relied on impermissible speculation. Back to you, David.
Thanks, Maria. Now Raj joins us with the latest on immigration and government law.
Thanks, David. 10 cases from the 10th, 11th, 4th, 9th, and federal circuits covering immigration appeals, administrative agency review, and Social Security matters. The disposition mix includes 5 denials, 2 dismissals, 2 affirmances, and 1 vacatur with a remand. Over in the Ninth Circuit, the court vacated and remanded 2 separate cases involving the state of Alaska challenging the Department of Interior's authority to take land into trust for Native American tribes. The court found appellate review premature because the department changed its position on appeal, no longer defending its decision to accept a Juneau parcel into trust and operating under a solicitor opinion recommending against accepting such applications in Alaska. Consequently, the district courts must reconsider how this change in viewpoint impacts the analysis under the Administrative Procedure Act. In the 10th Circuit, the court denied the petition for review in Martinez-Perez versus Bondi. The petitioner sought cancellation of removal based on exceptional and extremely unusual hardship to his U.S. citizen daughter, but the court held he was ineligible because she had turned 21 years old by the time the immigration judge ruled. The court further found that the petitioner failed to exhaust the theory of equitable tolling before the Board of Immigration Appeals. Moving to the 11th Circuit, the petition for review in Patel v. United States Attorney General was denied regarding a family's application for cancellation of removal. The board concluded there was no exceptional and extremely unusual hardship to their qualifying relatives, including a U.S. citizen daughter and a lawful permanent resident mother. The court applied a deferential substantial evidence standard and declined to reevaluate underlying factual determinations regarding credibility or medical care availability in India. In the 4th Circuit, 2 immigration petitions were denied. In Sandoval Cisneros v. Blanche, the court found no abuse of discretion when the board denied a motion to reopen, which was also construed as a motion to reconsider. In Flores Martinez and Perez Hernandez v. Blanche, the court held that substantial evidence supported the agency's finding that the petitioner failed to establish the necessary nexus between the feared persecution and a protected ground. Back in the 9th Circuit, the court denied Ixtabal and Sante v. Blanche regarding claims for asylum and relief under the Convention Against Torture. The court found the petitioner failed to establish a nexus between past harm and her proposed particular social group of nuclear family, noting the extortionists were motivated by criminal financial gain rather than persecution. The 9th Circuit also affirmed 2 other decisions. In Velázquez v. Bizignano, the court upheld the dismissal of a claim for Medicare Part B benefits due to failure to exhaust administrative remedies under the Medicare Act. In Kinikin v. National Security Agency, the court affirmed summary judgment for the government, holding that a House Appropriations Committee report was not an agency record subject to disclosure under the Freedom of Information Act because Congress clearly intended to retain control over it. Finally, in the Federal Circuit, the appeal in Absher v. the United States was dismissed by mutual agreement of the parties pursuant to Federal Rule of Appellate Procedure 42D. Back to you, David.
Okay, that is the Daily Rundown for Monday, August 24th, 2026. Subscribe or follow for the next update. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction.